appointed by the President. The Chief Justice is appointed by the President after consultation with such judges of the Supreme Court and High Courts as he deems necessary. The other judges are appointed by President after consultation with the Chief Justice and such other judges of the Supreme Court and the High Courts as he deems necessary. The consultation with the Chief Justice is obligatory in the case of appointment of a judge other than Chief Justice. Controversy over consultation. The Supreme Court has given different interpretation of the word consultation in the above provision. In the first judge's case 1982, the court held that consultation does not mean concurrence and it only implies exchange of views. But, in the second judge's case 1993, the court reversed its earlier ruling and changed the meaning of the word consultation to concurrence. Hence, it ruled that the advice tendered by the Chief Justice of India is binding on the President in the matters of appointment of the judges of the Supreme Court. But, the Chief Justice would tender his advice on the matter after consulting two of his senior-most colleagues. Similarly, in the third judge's case to 1998, the court opined that the consultation process to be adopted by the Chief Justice of India requires consultation of plurality judges. The sole opinion of the Chief Justice of India does not constitute the consultation process. He should consult a collegium of four senior-most judges of the Supreme Court, and even if two judges give an adverse opinion, he should not send the recommendation to the government. The court held that the recommendation made by the Chief Justice of India without complying with the norms and requirements of the consultation process are not binding on the government. Appointment of Chief Justice from 1950 to 1973. The practice has been to appoint the senior-most judge of the Supreme Court as the Chief Justice of India. This established convention was violated in 1973 when A.N. Ray was appointed as the Chief Justice of India by superseding three senior judges. 3. Again in 1977, M.U. Beg was appointed as the Chief Justice of India by superseding the then senior-most judge. 4. This discretion of the government was curtailed by the Supreme Court in the second Judge's Case 1993, in which the Supreme Court ruled that the senior-most judge of the Supreme Court should alone be appointed to the office of the Chief Justice of India. Qualifications of judges. A person to be appointed as a judge of the Supreme Court should have the following qualifications. A. Though he should be a citizen of India. A. He should have been a judge of a high court, or high courts in succession, for 5 years. Or B. He should have been an advocate of a high court, or high courts in succession, for 10 years. Or C. He should be a distinguished jurist in the opinion of the President. From the above, it is clear that the Constitution has not prescribed a minimum age for appointment as a judge of the Supreme Court. Oath or affirmation. A person appointed as a judge of the Supreme Court, before entering upon his office, has to make and subscribe an oath or affirmation before the President, or some person appointed by him for this purpose. In his oath, a judge of the Supreme Court swears 1. 2, 3, 4. To bear true faith and allegiance to the Constitution of India. To uphold the sovereignty and integrity of India. To duly and faithfully and to the best of his ability, knowledge and judgment perform the duties of the office without fear or favor, affection or ill will, and to uphold the Constitution and the laws. Tenure of judges. The Constitution has not fixed the tenure of a judge of the Supreme Court. However, it makes the following 3 provisions in this regard. 1. He holds office until he attains the age of 65 years. Any question regarding his age is to be determined by such authority and in such manner as provided by Parliament. 2. 3. He can resign his office by writing to the President. He can be removed from his office by the President on the recommendation of the Parliament. Removal of judges. A judge of the Supreme Court can be removed from his office by an order of the President. The President can issue the removal order only after an address by Parliament has been presented to him in the same session for such removal. 5. The address must be supported by a special majority of each House of Parliament, i.e., a majority of the total membership of that House and a majority of not less than 2/3 of the members of that House present and voting. The grounds of removal are to prove misbehavior or incapacity. The Judges Inquiry Act 1968 regulates the procedure relating to the removal of a judge of the Supreme Court by the process of impeachment. 1. A removal motion signed by 100 members in the case of Lok Sabha or 50 members in the case of Rajya Sabha is to be given to the Speaker Chairman. 2, 3, 4, 5, 6, 7. The Speaker Chairman may admit the motion or refuse to admit it. If it is admitted, then the Speaker Chairman is to constitute a 3-member committee to investigate into the charges. The committee should consist of A. the Chief Justice or a Judge of the Supreme Court, B. a Chief Justice of a High Court, and C. a distinguished jurist. If the committee finds the judge to be guilty of misbehavior or suffering from an incapacity, the House can take up the consideration of the motion. After the motion is passed by each House of Parliament by special majority, an address is presented to the President for removal of the judge. Finally, the President passes an order removing the judge. It is interesting to know that no judge of the Supreme Court has been impeached so far. The first and the only case of impeachment is that of Justice V. Ramaswamy of the Supreme Court 1991 to 1993. Though the inquiry committee found him guilty of misbehavior, he could not be removed as the impeachment motion was defeated in the Lok Sabha. The Congress party abstained from voting.